Hello friends, welcome back to the series of lecture. This is the 46th lecture of this series of Indian Evidence Act, and we are continuing with section 24, that is the topic confession. We had previously seen the admissions, and in admission there is self-harming admission, that is called confession, and when the confessions are relevant and irrelevant, that we have to see. And in 24 it is seen, we have to see that the confessions are when relevant in criminal proceedings. So first of all, write down Section 21. Section 21 declares the relevancy of admissions and therefore confessions which are also self-incriminating admissions will be relevant under Section 21. Since these are self-incriminating, they shall be allowed to be proved under Section 21. Thus, confessions are relevant and shall be allowed to be proved, excepting in the cases of Section 25 and 26, wherein, despite being relevant, it shall not be proved. Section 24 provides for the irrelevancy of confessions in certain circumstances. Next paragraph. If the confession has been obtained by threat, inducement or promise caused against the accused by a person in authority, then if the other conditions of Section 24 are fulfilled, the confession will be irrelevant. अब इसको पॉइंट्स में कन्वर्ट करते हैं. कंडीशंस आप लिखो इन पॉइंट्स. कंडीशंस लिखो. कंडीशंस ऑफ सेक्शन 24. पॉइंट नंबर 1. There should have been threat, inducement or promise to the accused. There should have been threat, inducement or promise to the accused. Number 2. The said threat, inducement or promise should have been in reference to the charge against the accused. That is, the threat, inducement or promise was related to the allegation and the proceedings against the accused. For example, the accused was threatened that if he does not make the confession, he will be given the most severe punishment, or that he will not be released on bail, or that third-degree torture will be caused to him, etc. Similarly, if the promise was, if he makes the confession, he shall be given less punishment, or be granted bail, etc., then it is in the reference to the charge. Then it is in the reference to the charge. Then it will be called that it is in reference to the charge. But if the inducement is that he will attain salvation. Salvation means moksha prapti. Salvation, or he will ease his own conscience. Or if the promise was that he will be paid money if he makes the confession, etc., then it is not in reference to the charge. Then it is not in reference to the charge. Now next point, third. Right. The threat, inducement or promise. The threat, inducement or promise should have come from a person in authority. This has to be given a liberal construction. This has to be given a liberal construction, and therefore it will include not only the investigating officer, rather also any officer superior or inferior to him, or any person working in the police station, the judicial magistrate or reader, or any officer associated with his office. The sarpanch the Mukhiya, etc. It will also include the wives of the above officers. The real test is as to whether such person apparently, the real test is as to whether such person apparently has the capacity to influence the proceedings or not. तो real test क्या है? The real test is as to whether such person apparently has the capacity to influence the proceedings or not. For instance, if the charge is of theft, criminal misappropriation, etc., then even the employer of the accused can be considered to be a person in authority. Point number 4. The accused should have made the confession under the said threat, inducement, or promise. Under the said threat, inducement, or promise in a belief that by making a confession he would gain some advantage or avoid an evil of a temporal nature. Temporal here means something which is worldly and material, and in reference to section 24. It has to be related to the charge or the proceeding. Thus, if the accused made the confession for some moral or spiritual benefits or to prevent himself from being socially outcast, it is not with reference to charge or proceeding. It is not with reference to the charge or proceedings. अब spiritual और moral benefit तो वैसे भी temporal नहीं होगा. Spiritual and moral benefit is not temporal. The social outcast वाला benefit is temporal, but again that is not with reference to the charge. So broadly this is what is in section 24. अब लेकिन next paragraph. Section 24 has to be given a restricted application and a strict interpretation of section 24. Section 24 has to be given a restricted application and a strict interpretation of section 24 shall be made. It is in a negative language. And a strict interpretation of section 24 shall be made. It is in a negative language. It simply declares what confessions will be irrelevant, and therefore whatever confession that does not fall under section 24 will be relevant. Next paragraph. Section 28 in this regard clearly declares that if the confession was made by the accused after the influence of the said inducement, threat, or promise was fully removed, then the confession will become relevant. Thus, if an accused is taken to the judicial magistrate for the recording of the confession, and the magistrate believes upon examination that the accused is acting under some inducement, threat, or promise, then he shall not record confession immediately, as that would become irrelevant. Therefore, he shall first make the accused sit in isolation. So, section 24 has to be given a restricted application and a strict interpretation of section 24 shall be made. It is in a negative language. It simply declares what confession will be irrelevant, and therefore whatever confession that does not fall under section 24 will be relevant. Section 28 in this regard clearly declares that if the confession was made by the accused after the influence of the said inducement, threat, or promise was fully removed, then the confession will become relevant. Thus, if an accused is taken to the judicial magistrate for the recording of the confession, and the magistrate believes upon examination that the accused is acting under some inducement, threat or promise, then he shall not record confession immediately, as that would become irrelevant. Therefore, he shall first make the accused sit in isolation. Therefore, he shall first make the accused sit in isolation, or he shall send the accused to judicial custody first, and thereupon, after a day or two, he shall record the confession. When the influence of inducement, threat or promise is fully removed, then such confession will be relevant and admissible. अब section 28 आप एक बार फिर से पढ़ लीजिए, then we will shift over section 29. If such a confession, such here refers to section 24. If such a confession as is referred to in section 24 is made after the impression caused by any such inducement, threat or promise as in the opinion of the court has been fully removed, it is relevant. Has been fully removed, it is relevant. Has been fully removed मतलब जो inducement, threat और promise जो section 24 में हुआ था, अगर वो पूरी तरीके से हट गया हो और उसके बाद confession हुआ है, then the confession will be relevant and admissible. अब who will ensure that it has been fully removed? The court will decide it. The court will examine, the magistrate will examine as to whether the effect has been fully removed. Now next you have to see section 29. Section 29. If such a confession is otherwise relevant, means if the confession made by the accused is otherwise relevant, it does not become irrelevant. Means basically it was relevant. Basically it is relevant. It is not falling in section 24, therefore it is relevant. It does not become irrelevant merely because it was made under a promise of secrecy. Now suppose there is a friend you have. Now your friend committed an offense and you promise him that you tell me, I will not tell you, I will not tell anyone, and you obtain the confession from him, and later on you give evidence in the court. Merely because you obtain the confession under a promise of secrecy, the confession will not become irrelevant. हाँ, अगर सेक्शन 24 में फॉल करेगा तो irrelevant हो जाएगा. हाँ, अगर उसके अलावा relevant है, अगर 24 में फॉल नहीं कर रहा, उसके अलावा relevant है, और आपने प्रॉमिस किया था कि मैं किसी को नहीं बताऊंगा, और फिर आपने कन्फेशन ले लिया, तो वो कन्फेशन irrelevant नहीं होगा, and you can always go on to prove the confession. Merely because it was made under a promise of secrecy or in consequence of a deception practiced on the accused person for the purpose of obtaining it. अब कोई उसके पास भेष बदल कर चला गया, कोई महात्मा बनकर चला गया साधु, और उससे बोला कि बच्चा बताओ तुमने क्या क्या अपराध किए, मुझको बताओ सब कुछ. You tell me everything about yourself, then I will give the methods of getting rid of it. Then this man gave all the details of that. Now again here it was under deception that you framed the confession. It was under deception and you obtained the confession, but still that confession will be relevant. But अगर पुलिस ऑफिसर भेष बदल कर जाता है तब सेक्शन 25 लगता है. If a police officer goes, then the section 25 will apply, but if a individual goes, then 25 will not apply and it will be relevant. Then also, or when he was drunk means this person, this accused, is in drunken state and then he make the confession. Now whatever be the state of the intoxication, if in the drunken state he made the confession, if he make the confession in the drunken state, then he cannot tell tomorrow that no, I was not normal, I made confession and now please give it back to me. So that he cannot do. तो ड्रंकन स्टेट में था फिर भी अगर कन्फेशन एडमिट कर लिया है, that will be relevant and allowed to be proved. Reading it again. If such a confession is otherwise relevant, it does not become irrelevant merely because it was made under a promise of secrecy or in consequence of a deception practiced on the accused person for the purpose of obtaining it, or when he was drunk, or because it was made in answer to questions which he need not have answered, whatever may have been the form of those questions, or because he was not warned that he was not bound to make such confession, and that evidence of it might be given against him. What is meant by because it was made in answer to questions which he need not have to answered. अब ये थोड़ा सा रेफरेंस कर रहा है आर्टिकल 20 क्लॉज 3 से कि आपसे सवाल पूछे गए, यू आर नॉट बाउंड टू मेक द स्टेटमेंट्स बट स्टिल यू मेड द स्टेटमेंट्स, दे डू नॉट थ्रेटन यू, नो वन थ्रेटन यू, किसी ने आपको धमकी नहीं दी, simply the questions were asked and you voluntarily made the answers, so there the confessions are still admissible. But suppose the police officer threatened you or any third person threatened you and then you gave the statements, the confession. If someone threatened you, then it is not allowed. पुलिस ऑफिसर ना भी हो, कोई और भी हो, अगर उसने धमकी देकर आपसे एडमिशन कन्फेशन लिया है, then it is not allowed. लेकिन अगर आपसे पूछा और आपने वॉलंटरली आंसर दे दिया, then even if you are not bound to answer those questions, the confession will be used as evidence against him. तो एक सेंटेंस रख लो आप इस पर. If the accused was not bound to answer the questions asked to him during interrogation, if the accused was not bound during interrogation but without any threat having been caused to him, if he voluntarily answers those questions and makes the confession, then the confession will still be relevant and admissible. If the accused was not bound to answer the questions asked to him during interrogation, but without any threat having been caused to him, if he voluntarily answers those questions and makes the confession, then the confession will still be relevant and admissible. मतलब कोई अगर आपसे सवाल पूछता है, then you are not bound to make the answers, give the answers. Still, अगर अपनी मर्जी से आपने confession कर दिया है, then that confession will be admissible. And obviously, if पुलिस को किया है, अगर पुलिस को किया तो then section 25 will apply. But as per declaration section 29 is, अगर आपसे कोई पूछता है, पूछताछ अगर मान लो पुलिस भी कर रही है, पुलिस ने मान लो आपसे पूछताछ की और आपने बिना धमकी के आपने उसके क्वेश्चन आंसर कर दिए, it will be relevant and it will be admissible. But again the point is that if it was a police officer or police custody, then 25-26 will apply. If it was a private individual who was interrogating you, if it was an executive magistrate who was interrogating you, and there it was not caused any kind of threat, etc., you voluntarily made the confession, even though you know that you are not bound to answer the questions, but you voluntarily made the confession, then that will be relevant and admissible. Now last point you see, or because he was not warned that he was not bound to make such confession, and that evidence of it might be given against him. Now suppose you are committed an offense. अब इसका रेफरेंस एक्चुअली 164 CRPC से, सेक्शन 164 CRPC से, तो उससे रिलेट कर रहा हूँ मैं. अब मान लो सपोज यू आर कमिटेड एन ऑफेंस and I am a private individual and I ask you tell me that what did you do. Now I am a private individual and I did not tell you that if you make a confession that it will be used against you and you are not bound to make the confession. मैंने ऐसा कुछ वार्निंग आपको नहीं दिया. And I asked you that what will you do, what you have done, and you tell me the entire confession. You told me the entire incident. So that confession is relevant and admissible. And merely because I did not warn you that you did not need to make the confession because you are not bound, and that your confession will be used as an evidence against you. अगर मैंने आपको ये दोनों वार्निंग नहीं दिया है, फिर भी the confession will be admissible because I am a private individual. But in reference to section 164, if a magistrate, judicial magistrate first class, if he records the confession, then he is bound to warn you. That is in 164 clause 2 CRPC. And clause 4 is there, 164 clause 4 is there, wherein their memorandum is being talked about, and in memorandum you also have to write that I had warned him. But duty to warn is there in section 164 clause 2 CRPC. Now there it is required that the magistrate is duty bound to warn the accused before taking the confession. In section 164 clause 2 it is required that the magistrate is duty bound to warn the accused before taking the confession that he is not bound to make the confession, and if he makes it, then it may be used in evidence against him. So this is the duty of the magistrate. When you read CRPC, you know that if this particular duty of magistrate is not fulfilled, then the confession will not be admissible. अब ये इस सेक्शन में यहाँ पर कुछ और लिख रहे हैं, यहाँ पर कुछ और लिख रहे हैं, और 164 में उल्टा लिख रहे हैं. यहाँ पर तो लिख रहे हैं अगर आपको वार्निंग नहीं दी गई, अगर आपको वार्निंग नहीं भी दिया गया था तब भी कन्फेशन एडमिसिबल होगा, और 164 में लिख रहे हैं कि वार्निंग देना जरूरी है. और 164 सीआरपीसी के साथ 463 गो फॉर द इर्रेगुलरिटीज. 463 सीआरपीसी, 463 सीआरपीसी में ये वाला जो एरर है ये रेक्टिफाई नहीं हो सकता. इर्रेगुलरिटीज में जो रेक्टिफिकेशन होता है, दूसरे छोटे मोटे एरर रेक्टिफाई हो सकते हैं, बट ये वाला एरर जिसमें मजिस्ट्रेट ने कन्फेशन से पहले वार्निंग ही नहीं दिया था, वो सीआरपीसी में पढ़ोगे आप. सीआरपीसी में आप पढ़ चुके हो जिसमें मजिस्ट्रेट ने वार्निंग दिया ही नहीं था, और मेमोरेंडम में उसने जो लिखना है वो लिखा ही नहीं क्योंकि उसने वार्निंग दिया ही नहीं था. So in that case, that error is not rectifiable under section 463. Now you see it is opposite. Magistrate, he has to give the warning. If he obtains the confession without the warning, then the confession is inadmissible. And if a private person does so, then he will be benefited by section 29 Indian Evidence Act. And even if he does not give the warning, the confession is admissible. Now you see section 29 in this regard is a general provision, and section 164 CRPC is a specific provision. So if a magistrate records the confession, then 164 will prevail. And if any other person takes the confession, then 164 is not applicable, then section 29 will apply. इसको आप लिख लो, write it down. It is clearly declared in section 29. It is clearly declared in section 29 that if the confession was obtained without warning, warning क्या है वो अपने आप लिख लेना, without warning the accused, then also the confession will be admissible. However, in this regard, section 164 CRPC clearly says that the judicial magistrate first record the confession, that the judicial magistrate first class recording the confession, judicial magistrate first class recording the confession shall first warn the accused before recording the confession. Here this provision is opposite to section 29, but section 164 clause 2 is a specific provision regarding the recording of confession by judicial magistrate first class, and therefore it will prevail upon the provisions of section 29 Indian Evidence Act. But in the cases of private individuals recording and taking the confession, section 29 will prevail. Means private individual अगर warning ना भी दे तब भी confession admissible होगा, लेकिन अगर magistrate first class warning के बिना record करता है, then that confession is not admissible by virtue of section 164 clause 2 N164 clause 4 read with section 463 CRPC. Let's see section 25 and 26. There is nothing much in this. Read 25. No confession made to a police officer shall be proved as against a person accused of any offense. No confession made to a police officer. You see, they are saying confession made to a police officer. मतलब आपने डायरेक्टली कन्फेशन पुलिस ऑफिसर को दिया है. You made the confession directly to the police officer shall be proved as against a person accused of any offense. अगर आपने कन्फेशन किसी पुलिस ऑफिसर को डायरेक्टली दिया है, then that confession shall not be admissible. But the confession even made to the police officer is relevant. Confession made even in police custody is relevant, but it is not admissible. अब यहाँ पर मेन पॉइंट आपको समझना है that who is a police officer. अब it means any police officer. जरूरी नहीं है इन्वेस्टिगेटिंग ऑफिसर हो, any police officer. यहाँ पर इन्वेस्टिगेशन से मतलब नहीं है, यहाँ पर मतलब है was it a police officer. So it can be any police officer, not the investigating only. But who is the police officer? Any person who has got, any officer who has got the power to investigate. I am not saying that to investigate that particular case. I am saying any person who has got the investigating powers will be considered to be a police officer. Now ordinary police officer की बात करें तो उनके सबके पास इन्वेस्टिगेटिंग पावर्स होता है, क्योंकि वो सारे के सारे पुलिस ऑफिसर होंगे. अब नॉर्मली तो आप देखोगे जो हेड कांस्टेबल से नीचे के होंगे, रैंक के पुलिस ऑफिसर्स होंगे, तो वो इंडिपेंडेंट इन्वेस्टिगेशन नहीं करते हैं, लेकिन छोटे केसेस में उनको भी इन्वेस्टिगेशन का पावर होगा. तो पुलिस ऑफिसर चाहे कोई भी हो, अगर उसके पास इन्वेस्टिगेशन पावर है, then he will be considered to be a police officer. एक कस्टम ऑफिसर या NDPS ऑफिसर, narcotic drugs, psychotropic substances, these officers are considered not to be having the power to investigate a case. These are considered to not having the power to investigate the case, and therefore they will not be considered to be a police officer for this purpose. लेकिन एक एक्साइज ऑफिसर, एक्साइज डिपार्टमेंट के ऑफिसर्स हैं, they do have the investigating powers, and therefore they will be considered to be a police officer. Write down, any officer who has the independent investigating powers will be considered to be a police officer for the purpose of section 25, and therefore an ordinary police officer or an excise officer having investigating powers will be considered to be a police officer for the purpose of section 25. Therefore, an ordinary police officer or an excise officer having investigating powers will be considered to be a police officer for the purpose of section 25. A customs officers or NDPS officers do not have independent investigating powers, and therefore they will not be considered to be a police officer. It is essential that the confession was made directly to the police officer, and therefore if confessional statement sent to the police officer by a letter, then that will not be hit by section 25. The rationale behind the section 25 or 26 is the implicit element of fear that would be caused to the accused if the confession was made to the police officer or while in police custody. तो जो पुलिस ऑफिसर को जो देते हो कन्फेशन, तो वो जो डर जो होता है, या पुलिस कस्टडी में होते हुए जो डर होता है पुलिस कस्टडी की वजह से, because that fear element is involved, therefore these are not admissible. But if you write a letter to the police officer, you write that letter, post that letter from the post office, so there is no fear element involved. and therefore it will not be hit by section 25. अगर कोई पुलिस ऑफिसर भेस बदल कर आपसे कन्फेशन लेता है तो वैसे तो उसमें सेक्शन 25 नहीं लगना चाहिए, लेकिन क्योंकि पुलिस ऑफिसर है तो just as a matter of precaution, here also we will say that it is actually hit by section 25. So write down, but if a letter written and post to police officer, then it is not hit by section 25 because no fear element is in it. Then also write, even if a police officer under disguise base badalkar obtains a confession, the said confession will be hit by section 25 as a matter of precaution. For section 25, it is not essential that the accused should have been in police custody at the time when the confession was made. अब पुलिस कस्टडी जरूरी नहीं है जब आप कन्फेशन कर रहे हो, बिना पुलिस कस्टडी के भी आप पुलिस ऑफिसर को देते हो. Then also hit by section 25. Now suppose I have committed an offense and I go to the beat box and I told to the police officers that I have committed so and so offense. अब मैंने उनसे दूर खड़े होकर बोला, मैं उनके पकड़ में नहीं आया, भाग गया. Then it will hit by section 25 because for section 25 it is not necessary that I should be in custody. Now let's see section 26. No confession made by any person while he is in the custody of a police officer. No confession made by any person while he is in the custody of a police officer unless it be made in the immediate presence of a magistrate shall be proved as against such person. No confession made by any person while he was in police custody shall be admissible unless it was made in the immediate presence of a magistrate. Magistrate here means judicial magistrate. अब पुलिस कस्टडी का क्या मतलब होगा? देखो, दो तरीके की कस्टडी होती है, एक होती है पुलिस कस्टडी और एक होती है जुडिशियल कस्टडी. कस्टडी इज ऑफ टू टाइप, पुलिस कस्टडी एंड जुडिशियल कस्टडी. यहाँ पर दे आर यूजिंग द वर्ड पुलिस कस्टडी. अगर जुडिशियल कस्टडी है देन इन दैट केस यू वुड बी इन जेल, एंड इफ इट इज पुलिस कस्टडी देन in that case you would be in police lockup or maybe any other similar place. At times they don't keep you in police lockup, they have got special places to keep the accused for interrogation, where they also do the third degree torture etc, which is illegal. कई बार मकान भी किराए पर लेकर रखते हैं, खासकर क्राइम ब्रांच वाले, क्योंकि पुलिस लॉकअप में ज्यादा मारपीट करेंगे तो पता पड़ जाएगा लोगों को, शोर शराबे से न्यूज वाले भी रहते हैं. और कोई ऐसी जगह पर ले गए जो पुलिस ने ले रखा अलग से, तो उधर वो ऐसी जगह लेते हैं जहाँ सिर्फ आसपास मैदान होता है, मकान और चारों तरफ मैदान. तो बहुत सारी चीजें अगर लॉ के अनुसार चलो तो बहुत सारी चीजें ऐसी हैं जिसको आप नहीं कर सकते. फॉर एग्जाम्पल, हाउ कैन ए क्राइम ब्रांच पीपल कम ओवर इन सिविल ड्रेस इन देयर प्राइवेट व्हीकल्स एंड दे विल गेट इनटू योर हाउस. They will push the other family members, then they will grab you, they will drag you, and they will throw you into the car, and they will take you to similar kind of place, and they will keep you there for 2-3 days, 4 days, as long as they want, and you are not aware also. Initially तो you are not aware कि मुझे गुंडे लेके जा रहे हैं पुलिस वाले, because they are not having any visible mark, and they are not telling you, and later on if they find you innocent, तो आपको मरहम पट्टी करके वापस भेज देंगे. एंड इफ दे फाइंड दैट यू आर नॉट इनोसेंट देन नाउ दे विल मेक अ फॉर्मल अरेस्ट एंड दे विल शो दैट दे हैड अरेस्टेड यू समवेयर not in the manner they have arrested. They will not show the manner in which they have arrested. They will show somewhere else they have arrested you and then they will handed over you to the regular police. अब वो 3-4 जो दिन थे आपके गिरफ्तारी के पहले, उसका क्या करोगे, वो कहाँ जाएगा? तो दैट इज प्योरली इलीगल. आप याद करो डी के बसु वर्सेस स्टेट ऑफ वेस्ट बंगाल 1997 सुप्रीम कोर्ट का केस, उसमें गाइडलाइंस दे रखे हैं, उसको पढ़ो. देन सीआरपीसी की प्रेजेंट गाइडलाइंस पढ़िए आप. CRPC में provisions are there, so there should be a visible mark. Even you are in a civil dress, there should be a visible mark which shows that as to who you are. Normally तो civil dress में आपको arrest नहीं करना चाहिए. You should be in the police dress and you should be at least reveal your identity, show your badges. Plus then you should prepare the arrest memo. जहाँ पर गिरफ्तार किए वहाँ के आसपास के 2 witnesses या family members थे, आप साइन करवाओगे and you should tell them as where you are taking this person for interrogation purpose, etc., etc. So all those guidelines becomes illusory when this crime branch people make the arrest in such a manner. But again, just for justifying them, अगर हर चीज लॉ के अनुसार करेंगे तो क्रिमिनल्स, जो हार्डकोर क्रिमिनल्स हमारे ऐसे लोग हैं सोसाइटी में, वो कभी पकड़ में ही नहीं आएंगे. जस्ट फॉर जस्टिफिकेशन, जस्टिफाइंग देम. So there are certain powers which are impliedly allowed by the different bodies, but they may be changed as our society get more and more civilized and such kind of criminals for which these are allowed, they are reduced into less numbers. But now also जो Human Rights Commission वगैरह है, they even strongly oppose such kind of actions. जो die hard ह्यूमन राइट्स वाले हैं वो तो इवन नॉट सपोर्ट द डेथ सेंटेंस इन एनी केस. अब इज इट राइट कि गैंग रेप केस में विद चाइल्ड और गर्ल और इन टेररिस्ट अटैक केस जैसा अफजल गुरु केस था, सो इन सच काइंड ऑफ केसेस द डेथ सेंटेंस शुड बी रिमूव्ड. So that will not be just and proper for the society also. There should be balancing of interest. क्योंकि the person several times, जो हार्डकोर क्रिमिनल्स होते हैं उनके इतने लिंक होती हैं, अगर जेल में भी रहेंगे तो वो सारी चीज कर सकते हैं जो बाहर रहकर कर सकते हैं, और उससे ज्यादा भी. They are more dangerous than that because they are in the security. For example, निर्भया केस में even though they are drunk, तो इतने भी ज्यादा ड्रंक नहीं थे, और ड्रंक थे भी तो when she opposed or said something, so on the spot they have taken such kind of acts in a manner of revenge. जब तुमको इतना होश हो सकता है, then what are you doing? You are well aware of that kind of acts. क्योंकि उस केस में they are not personally aware each other. पहले कोई ऐसा था नहीं कि उसकी प्रॉपर्टी छीन लिया, कुछ कर लिया, ऐसा उसका बदला ले रहे. In the Nirbhaya case, it was on the spot that everything was happened. So they are not taking revenge from her for something that earlier she had done to them. अगर ऐसा होता तो you can also think that, then you can think that she may have done something wrong, but she had not done any wrong to any of them, and you have brutalized her like anything, even an animal not brutalized like that to any kind of act that they did. Inserting the iron rod in the private part and taking out the intestine, all everything, such kind of brutal act, and you throw the boy naked on the road. Now if there would be no death sentence, then these people would be in jail and they will be having all facilities. और ये facilities कहाँ से आता है? From the taxpayers. We the taxpayers. And these people not deserve to be remain in the society, and they are in the jail. If you are giving them all the facilities, then these places where they are staying, they will bear expenses on whose cost? At the cost of the society, and in the society the victim के mother father भी आएंगे, relative भी आएंगे, so उनका भी पैसा. So see the things in that ways also. अब जुवेनाइल का तो लॉ अलग है, उसको हटा दो, तो पर्सनल फीलिंग्स को हटा दो और लॉ को हटा दो. But what about the other people? How can we think of that these people will continue to live in the society at the cost of the society and the kind of brutal act they had done? Now that is a different thing, and lack of investigation or the wrong acts of the investigating agencies. अगर किसी दोषी को निकाल कर वो निर्दोष को फंसा देते हैं तो उसके लिए अदर एक्ट होने चाहिए, but we are talking about the culprits only. So anyway, we are talking about the custody, that is police custody and judicial custody. तो जब भी जुडिशियल मजिस्ट्रेट आपको जुडिशियल रिमांड पर भेजेगा, जुडिशियल कस्टडी में भेजेगा, तो होता है ना जब आप गिरफ्तार होते हो, यू अप्लाई फॉर बेल, पुलिस विल अप्लाई फॉर पुलिस रिमांड and the judicial magistrate may give neither bail nor police custody, and he send you where the remaining thing is judicial custody, or maybe after the initial 15 days of the police remand he has to give you the judicial custody. So judicial custody is a place where you are in the custody of court, that is judicial custody, and you are kept into the jail. Police custody is where you are arrested by the police and you are taken to the police lockup. You are arrested by the police officer somewhere and you are taken to the police station. That is police custody. Then after that, they will produce you before the magistrate within 24 hours and they will obtain the police remand. Maximum 15 days का police remand मिलता है in one FIR. Maximum 15 days in one FIR. So that period for which you are sent to the police remand, that will be police custody. एक बार आपको जुडिशियल कस्टडी में भेज दिया तब फिर वो पुलिस कस्टडी नहीं माना जाए. So when they say police custody, so that kind of police custody they are talking about. When the accused has been arrested and he has taken to the police station, or maybe he was injured, or maybe for medical examination, he is taken by the police officer to the hospital. So there also he is in constructive custody. अब हॉस्पिटल में मान लो he is inside the room, doctor is examining him and the police officer is standing outside. That is also a constructive police custody. So police custody may be a constructive police custody or direct police custody, but as long as you are in police custody, suppose the police officer is standing outside, there is a hospital, the accused is inside with the doctor, and there you make confession to the doctor that I did so and so offense. Now this is again hit by section 26 because here he is still considered to be in police custody. It is a constructive police custody. क्योंकि पुलिस ऑफिसर बाहर तो खड़ा है, तो इट इज a constructive police custody. तो आप कंस्ट्रक्टिव पुलिस कस्टडी में हो या डायरेक्ट पुलिस कस्टडी में हो, पुलिस लॉकअप में हो या फिर किसी और जगह पर यहाँ पर पुलिस ऑफिसर आपको ले गया हो वहां पर हो, अगर आप कन्फेशन करते हो पुलिस कस्टडी में, तो बेशक आप पुलिस ऑफिसर को ना करके किसी प्राइवेट इंडिविजुअल को भी कर दो, फिर भी दैट विल हिट बाय सेक्शन 26. Now in my example, the doctor was not a police officer. You make confession to the doctor, but when you were in constructive police custody, and therefore your matter will be hit by section 26. अब जैसे आप हवालात में बंद हो, पुलिस लॉकअप हवालात में बंद हो, उधर एक और एक्यूज्ड है, आपसे पूछा कि भैया तुम क्या करके आए, तो आपने उसको कहानी बताई, आपने पूरी कहानी बताई उसको. अब वो पुलिस ऑफिसर तो नहीं है, लेकिन हवालात में दोनों बैठ के बातें कर रहे हैं, आपने उसको कहानी बताई, लेकिन है तो पुलिस कस्टडी, and therefore it will hit by section 26. So write down, देखो एक पॉइंट, police custody can be a direct police custody or a constructive police custody. Either ways, if the confession was made while the accused was in custody, it will be hit by section 26. However, while in such custody, if the confession is made before a judicial magistrate, then section 26 will not apply, provided at the time of the confession the police officer was not present inside the room. So he implied, provided at the time of the confession the police officer was not present inside the room. Now जब पुलिस ऑफिसर आपको गिरफ्तार करेगा, he will take you into the interrogation. तो पुलिस कस्टडी के लिए आपको पुलिस ऑफिसर मजिस्ट्रेट के पास ले जाएगा, और फॉर रिकॉर्डिंग ऑफ कन्फेशन पुलिस ऑफिसर ले जाएगा आपको मजिस्ट्रेट के पास. अब पुलिस रिमांड के समय तो चलो पुलिस ऑफिसर अंदर खड़ा रहे, ही विल सीक द रिमांड, लेकिन अगर कन्फेशन रिकॉर्डिंग के लिए ले जाता है, देन देयर द रूल इज दैट द पुलिस ऑफिसर विल नॉट बी इनसाइड. तो कन्फेशन रिकॉर्ड हो रहा है, नॉर्मली इट विल डन इन द ओपन कोर्ट, so the police officer should be out of the court. गेट पे खड़े रहे, भले ही बाहर खड़ा रहे, but not inside the court. गेट पे खड़ा रहेगी जिससे भागे ना एक्यूज, लेकिन अंदर नहीं खड़ा होगा। अब बाहर खड़ा है, गेट पे खड़ा है, देन 26 विल नॉट अप्लाई। अदरवाइज अगर अंदर खड़ा है देन द 26 विल अप्लाई। अब एक छोटा सा पॉइंट है, मान लो एक बार पुलिस ऑफिसर गिरफ्तार कर गए एक्यूज को। He was taken from one place to another. Suppose the police officer arrested an accused and he is taking him from one place to another. And on the way, suppose the police officer has to go to toilet or somewhere. So he handed over the accused to some person who is present there. कि आप इसको पकड़ कर रखो, मैं अभी आ रहा हूँ। अब this accused make the confession to other man. He makes the confession to that other man. Will it be hit by section 26? Still it will be hit by section 26 because still you say that it is a case of constructive custody. क्योंकि पुलिस ऑफिसर ने अपने लिए तो उसको बोल रखा था कि तुम पकड़ के रखो, मैं आ रहा हूँ। So that is a case of constructive custody. अब custody का main point is did the police officer has the effective control upon the movement of the accused. Did the police officer have an effective control upon the movement of the accused? If yes, then it will be set to the case of custody. Now एक point है कि any confession made to a police officer who is in civil clothes. तो जो disguised के लिए लगेगा वही civil clothes के लिए लगेगा. As a matter of precaution, it will hit by section 25. Civil clothes में है या disguised है फिर भी 25 लगेगा. तो हमने 24 देख लिया, then 25 देख लिया, then 26. 24 में कह रहे हैं it is irrelevant. 25, 26 कह रहे हैं it is relevant but it is inadmissible. अब now we see 27 and 27 is saying something and it starts with the word provided that. What this word indicate? Provided that. It is indicating as if it is a proviso of section 26. जिस section के बाद ये provided that लिखा है, 26 के बाद ये लिखा है. If it is written after 26, now obviously it seems to be a proviso provided to the section 26. But we know that it is not only the proviso of 26, it is the fact proviso for 24, 25 and 26. ये तीनों का proviso. Apparently it is the proviso of 26, but actually it is the proviso of 24, 25 and 26. All. एक बार पढ़ लो आप 27. Provided that when any fact is deposed to as discovered in consequence of the information received from a person accused of any offence in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered, may be proved. So it is talking about provided that when any fact discovered in consequence of what? Information given by accused. Any fact is discovered in consequence of information given by an accused while the accused was in police custody. While the accused is in police custody. पूरा पढ़ रहा हूँ एक बार. Provided that when any fact is deposed to as discovered. Discovered means what? Found. In consequence of information received from a person accused of any offence in the custody of a police officer. तो अगर एक व्यक्ति accused है और वो पुलिस कस्टडी में है, एक व्यक्ति accused है और वो पुलिस कस्टडी में है और पुलिस कस्टडी में रहते हुए उसने कोई एक इंफॉर्मेशन दिया और उस इंफॉर्मेशन के कंसिक्वेंस में उस इंफॉर्मेशन के बेसिस पर एक फैक्ट डिस्कवर हुआ, then they are saying further, if you read, so much of such information, what information? That information that accused gave, whether it amounts to a confession or not. अब जरूरी नहीं that information is confessional, it can be a confessional information or it can be a not confessional information also. जो स्टेटमेंट accused ने दिया वो confessional भी हो सकता है और नॉन कन्फेशनल भी हो सकता है, लेकिन एक्यूज्ड उस समय पुलिस कस्टडी में होना चाहिए। So much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered, may be proved. So much of information, as relates distinctly to the fact thereby discovered, shall be proved, may be proved. तो आप मतलब उस इंफॉर्मेशन का कितना पार्ट आप प्रूव करोगे सेक्शन 27 में? Only as much as distinctly relates to the fact discovered. सिर्फ इतना रेलिवेंट होगा, सिर्फ इतना एडमिसिबल होगा। उस स्टेटमेंट का बाकी का पार्ट एडमिसिबल होगा कि नहीं होगा दैट इज इमैटेरियल, लेकिन 27 में एडमिसिबल नहीं होगा। 27 में दैट पार्ट ऑफ द स्टेटमेंट इंफॉर्मेशन विच रिलेट्स टू द डिस्कवरी ऑफ दैट फैक्ट विल बी रेलिवेंट। अब इस पर लिख लीजिए एक पॉइंट, आप टॉपिक का बैकग्राउंड लिख लीजिए। Whenever an accused is arrested and is in police custody, he may make a confessional statement or any other statement which any confessional statement or any other statement which is not confessional. In that statement, he may disclose the whereabouts of a particular objects, whereabouts मतलब place of hiding, whereabouts of a particular objects such object may have a connection with the crime that he has committed for example a murder weapon, the dead body, the blood stained clothes, जो खून लग गया हो कपड़ों पर वो छुपा दिए हो उसने, the blood stained clothes, or in the case of theft, the stolen property. So these are some examples. The police officer in such a case will record that statement which is called a disclosure statement. The police officer in such a case will record that statement which is called, क्या बोलेंगे इसको, डिस्क्लोजर स्टेटमेंट। इसको अभी डिस्कवरी स्टेटमेंट नहीं बोलेंगे। Initially it will be called a disclosure statement, which is called a disclosure statement. Disclosing means what? I am disclosing the fact that where is the object or where the object is. अब सिर्फ इतना ही रिकॉर्ड नहीं होगा, पूरा स्टेटमेंट रिकॉर्ड होगा। अब सपोज I am accused and I make a statement in the police custody. I make a full statement. Now in that full statement there will be some sentence wherein I will say that the object is lying in such and such place. So the entire statement will be recorded and the disclosure part is the part of that statement. Then thereafter the accused will be taken by the police to the place which he has suggested in the disclosure statement, in his disclosure statement, and he will be required to pinpoint the place. Upon his pinpointing, the object will be discovered from such place in the presence of two, और कई बार one भी चल जाएगा, one or two witnesses, possibly the inhabitants of that locality, possibly the inhabitants of that area, society or locality. आगे लिखो. Right, a discovery memo will be prepared in which the details of discovery will be recorded and the witnesses will sign upon the memo. Once the discovery has been made, the statement will now be called a discovery statement. दोनों है एक ही बात। डिस्कवरी के पहले you will call it disclosure and discovery के बाद you will call it discovery statement. The statement now will be called a discovery statement. अब ये जो आपको लिखवाया है, this is what happens whenever you have to discover something. अब suppose the accused A is in police custody. Suppose accused A को पुलिस ने गिरफ्तार कर लिया. While he was in police custody, he makes a confession to the police. He makes a confession to the police officer. Suppose there is a confessional statement. He had said everything in his confessional statement, but one sentence or two sentences in his confessional statement is wherein he says that I have hidden the object. अब इसमें एक दो सेंटेंस उसमें ये कहता है I have hidden the object. The object means क्या? The murder weapon. Suppose it is a case of murder. Suppose it is a pistol. I have hidden the murder weapon. जैसे वो था आपका दूधनाथ पांडे वाला केस जिसमें वो कट्टा मिला काऊ डंग के हीप के अंदर. So he stated that I have hidden the katta or the murder weapon under the heap of cow dung near the Hathi Park. Suppose he says that, and he confesses everything. He confesses that I am having enmity with them. I wanted to kill him. In morning I went to the factory where I came out immediately. I went to the Hathi Park there. There I waited for him, and when he came I stopped him and I shot and killed him. And I hid the katta under the heap of the cow dung. So that is the broad confessional statement, but you must realize that the confession made to the police officer is inadmissible. तो confession inadmissible होगा. पुलिस कस्टडी में था तो सेक्शन 26 लगा लो, अदरवाइज डायरेक्टली पुलिस को कर रहा है तो 25 लगा लो. So either in 25 or 26 the confession is inadmissible. But section 27 says that part of the statement which distinctly relates to the finding of the object that will still be admissible. Confession तो inadmissible हो गया 25-26, लेकिन उस स्टेटमेंट का, इस पूरे स्टेटमेंट का वो वाला पार्ट which distinctly relates to the finding of the object shall be admissible. Relevant तो already है but shall be admissible. Now what would happen is this police officer when take him to the spot. वो मान लो हाथी पार्क पे ले गया और काऊ डंग का हीप है उधर ही. He will taken to that spot and the police team go along with him, or maybe 2 or 3 police officers go along with him, and उस एरिया के जो लोकल witnesses हैं, if there are some people residing there, so one or two witnesses of there will be called. If there is no people residing there, then maybe the police officer can carry some independent witness along, and the police will there ask the accused where is the object, and the accused will pinpoint कि यहाँ पर है, या फिर he will himself take out the object from there. Either ways, या तो पुलिस को बताएगा यहाँ पर है, then the police officer will take out it from there, or the accused will himself take out the object from there, from the place of hiding. And now the moment this object is discovered from there, then this statement now will be called discovery statement. और एक डिस्कवरी मेमो बनेगा जिसमें लिखा जाएगा कि दिन के इतने बजे इन पुलिस ऑफिसर्स के सामने इस जगह पर at so and so place, at such a place, so and so object was hiding and discovered. और ऑब्जेक्ट का पूरा डिटेल्स लिखा जाएगा वहाँ पर. पिस्टल है तो उसका नंबर वगैरह सब कुछ लिखा जाएगा. Such and such object was discovered, and then the witness of discovery who was present there, he will put their signature upon the memo. That is what is called the discovery memo. Witness का signature इसलिए लगता है कि कल को ये डाउट हो जाए कि कहाँ पर डिस्कवर हुआ. Then the witness will examine in the court. After summoning the court, they will examine and they will say that the object will discovered from here. And the police officer, if wants, then he may do even the videography of the entire incident to provide a kind of authenticity. मोबाइल से वीडियोग्राफी कर लेते हैं कई बार, to provide the authenticity to the fact that there was actually a discovery. This entire process, this is what is called the process of discovery of the object. This process was called, entire process was called the discovery process of the discovery of the object. और जो वो मेमो बना दैट विल बी कॉल्ड द डिस्कवरी मेमो, एंड द स्टेटमेंट दैट ही हैड मेड वाज अ कन्फेशनल स्टेटमेंट, बट उसी को आप कहोगे डिस्कवरी स्टेटमेंट। उसी का वो पार्ट जो उस ऑब्जेक्ट से रिलेटेड है दैट विल बी कॉल्ड डिस्कवरी स्टेटमेंट। अब व्हाट इज द रैशनल बिहाइंड दैट डिस्कवरी स्टेटमेंट विल बी एडमिसिबल? पूरे का पूरा कन्फेशनल तो एडमिसिबल नहीं किया। दे आर राइटिंग क्लियरली as much of that statement as distinctly relate to the discovery will be admissible. So this whole confession, it is held by section 25, that will not be admissible, but that part of that confession which relate distinctly to the finding of the object, that part will be admissible. This is what is called the discovery statement. अब what is the rational? अब rational ये है कि how did the person know that the object will lying there? Means he himself committed the crime. He has committed the crime and he has kept the object there. Therefore he knows that the object will lying there. अब मान लो वो गया डिस्कवरी के लिए और वहां पर ऑब्जेक्ट मिला ही नहीं, तब तो वहां तो नो रेलिवेंसी, नो एडमिसिबिलिटी। Suppose he went to the spot and the object was not found there, then obviously the discovery statement is not there. Discovery statement is not there then, because the object is not found. तो अगर ऑब्जेक्ट मिल गया है, then the reason behind it as to how did he know that the murder weapon is lying there in this example, because ultimately ballistic expert से ये प्रूव तो हो जाएगा that this is the murder weapon, उसी ने गोली चलाई थी। Ballistic expert will prove that this is the weapon from which the bullet was shot. So how did he know that the murder weapon is lying there? How did he know that the dead body is lying there? How did he know that the stolen object is lying there? So that rationale, और उसी को कहते हैं the theory of confirmation by subsequent finding of fact. तो उसी को कहते हैं the theory of confirmation by subsequent finding of fact. Theory of confirmation by subsequent finding of facts. इसको लिखिएगा write down. The admissibility of discovery statement is based upon the concept of confirmation by subsequent finding of facts. By subsequent finding of facts. Now confirmation of what? Confirmation of what? Confirmation of truthfulness of disclosure statement. Confirmation of truthfulness of the disclosure statement. मतलब मैंने आपको बताया कि पिस्टल वहां पर है, तो ये तो डिस्क्लोजर हुआ। मैंने पुलिस को बताया कि पिस्टल वहां रखा है, दैट इज अ डिस्क्लोजर। लेकिन बाद में मेरे पिन पॉइंटिंग पर पिस्टल वहीं पर मिला। मीन्स व्हाट? मेरा जो नॉलेज था कि पिस्टल वहां है, उस नॉलेज का ट्रूथफुलनेस कंफर्म हो गया। एंड देयरफॉर द लॉजिक इज दैट हाउ डिड आई नो दैट द ऑब्जेक्ट इज लाइंग देयर? Now that is what is called theory of confirmation of what? Confirmation by confirmation of my statement का truthfulness. Confirmation of truthfulness of my knowledge of the fact by subsequent finding of the facts. So confirmation of truthfulness of disclosure statement by subsequent finding of facts. Subsequent means what? Today I make a disclosure, then later on subsequently the object is found. Fact means what? That object is found from the very place. That is what is called the confirmation by subsequent finding of facts. अब देखो इसमें रेलिवेंसी जो है वो 3 बातों की है, इसको लिख लो आप। Here relevancy is of 3 things. First one is accused knowledge of what? Of where the object is. दूसरा, the object being discovered from there only. The object being discovered from that place only. और तीसरा, the place of hiding. और उसी से पुलिस को place of hiding भी तो पता चल जाता है। So there are three things which are important here. One is knowledge, accused knowledge, which is corroborated by the fact that the object is found from there itself and the place where the object was found. और उसमें सबसे इम्पोर्टेंट है एंड द मेन पॉइंट दैट द नॉलेज ऑफ द एक्यूज्ड, क्योंकि अब ऑब्जेक्ट वहीं से मिल गया तो एक्यूज हैड द नॉलेज दैट द ऑब्जेक्ट विल फाउंड वेयर. सो हाउ डिड द एक्यूज्ड हैज द नॉलेज दैट द ऑब्जेक्ट इज लाइंग देयर? सो दैट इज द लॉजिकल रेलिवेंसी ऑफ द डिस्कवरी स्टेटमेंट. तो इसको लिख लीजिएगा प्लीज. सिंस द ऑब्जेक्ट हैज बीन डिस्कवर्ड फ्रॉम द सेम प्लेस which has been suggested by the accused, a logical question arises as to how did the accused know as to where the object is. The finding of the object at the same place which he disclosed creates a logical connection between accused and the offense. मतलब accused को कैसे पता चला कि object वहाँ है? मान लो accused कहता है कि डेड बॉडी एक कुएं में है, तो अब एक्यूज्ड को कैसे पता पड़ा कि डेड बॉडी कुएं में? कुएं में मतलब तैर नहीं रही है, छुपा हुआ अंदर. मान लो उसने पत्थर बांध कर फेंका था. अब एक्यूज्ड को कैसे पता कि कुएं में डेड बॉडी है? So obviously he was involved and there are some other circumstantial evidences, so they all will together corroborate each other and he can be convicted. So that is where the relevancy of section and admissibility of disclosure statement lies. अब you see what they are saying is, as much of the statement as distinctly relates, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered. पढ़ लो एक बार फिर से. Provided that when any fact is deposed to as discovered in consequence of information received from a person accused of any offense in the custody of a police officer, so much of such information. अब information तो काफी बड़ा होगा. It may be a confessional or non-confessional statement, but it will be a big information. So much of such information, whether it amounts to a confession or not. तो इधर से पढ़ो. So much of such information as relates. So much of such information as relates distinctly. Distinctly means what? Clearly, separately. As distinctly relates to the fact thereby discovered may be proved. Now suppose the information is, for example, that I killed X. I killed him with a knife. I stabbed him twice in the abdominal. उसके पेट में 2 बार चाकू मारा. I have hidden the knife. And it is hidden under the rock behind the शिव टेम्पल, शिव मंदिर. मतलब जो मर्जी हो उसने कोई कहीं जगह बता दी एक पर्टिकुलर. अब ये कन्फेशनल स्टेटमेंट है एक एक्यूज्ड द्वारा. ये सारे एक्यूज्ड कह रहा है कि मैंने मारा एक्स को. अब I killed X, it is hit by section 25. This statement, I killed him with a knife, this also hit by section 25. I stabbed him twice in the abdominal. This also hit by section 25. अब ये statement है I have hidden the knife. Whether it would hit by section 25 or not. अब दो चीजें, that I have hidden the knife and where would I hidden that knife. Where I have hidden the knife. It is hidden under the rock behind the शिव मंदिर. अब ये जो है इसको मैंने 2 सेंटेंस में लिखा है ये वाला पार्ट. अगर इसको एक सेंटेंस में लिखते तो कैसे लिखते? I have hidden the knife under the rock behind the शिव मंदिर. तो ये पूरा एक सेंटेंस है. I have hidden the knife under the rock behind the शिव मंदिर. अब इसमें से ये जो hidden वाला पार्ट है, that first part, hidden वाला पार्ट है, that is not relevant under section 27. कि मैंने छिपाया. That is not our concern. किसने छिपाया हमें उससे मतलब नहीं है. हमारा कंसर्न है नाइफ है कहाँ. आप दो चीजें कह रहे हो. जब आप कहते हो कि मैंने नाइफ को छिपाया है एक पत्थर के नीचे मंदिर के पीछे, शिव मंदिर के पीछे, तो इस सेंटेंस में उतना ही पार्ट रेलिवेंट होगा और एडमिसिबल होगा सेक्शन 27 में जितना डिस्टिंक्टली उस ऑब्जेक्ट के फाइंडिंग से रिलेट करता है. अब इस सेंटेंस को दो पार्ट में समझो आप, इसको ही दो पार्ट में लिख दिया मैंने। आई हैव हिडन द नाइफ, ये एक पार्ट है, एंड वेयर आई हैव हिडन द नाइफ, अंडर द रॉक बिहाइंड द शिव मंदिर। तो इसका जो ये वाला पार्ट है, आई हैव हिडन द नाइफ, दैट इज नॉट एडमिसिबल अंडर सेक्शन 27, so that is also hit by section 25, but the knife is there behind the शिव मंदिर under the rock। ये जो पार्ट है, that the knife is there behind the शिव मंदिर under the rock, उस सेंटेंस का ये वाला पार्ट, this severally and distinctly relates to the finding of the knife, and therefore that part alone will be admissible under section 27। तो इस एग्जाम्पल पर लिखिएगा एक पैराग्राफ छोटा सा। Here the rest of the confessional statement will be hit by section 25। Here the rest of confessional statement will be hit by section 25, but that part of the statement which distinctly relates to the finding of that object will be admissible under section 27। The fact that he had hidden the knife at that place will not be admissible, as a conduct of hiding the knife is not distinctly related to the finding of object. Rather, that part of a statement which declares that the object is lying under the rock behind the शिव मंदिर is admissible। मतलब ऑब्जेक्ट कहाँ पर है वो सेंटेंस में से निकालना है। अब मान लो एक सेंटेंस में अदर थिंग भी है, तो उस सेंटेंस को दो पार्ट में ब्रेक कर दो। जैसे ये कंप्लीट सेंटेंस होता कि आई मर्डर्ड एक्स बाय स्टैबिंग हिम ट्वाइस एंड आई हैव हिडन द ऑब्जेक्ट द मर्डर वेपन नाइफ बिहाइंड द शिव मंदिर अंडर अ रॉक। तो दिस इज वन कंप्लीट सेंटेंस। अब इसको भी आप बाइफरकेट करोगे, आई हैव स्टैब्ड बी किल्ड हिम, आई हैव हिडन द नाइफ उसको हटा दो, आई हैव स्टैब्ड बी उसको हटा दो, आई हैव हिडन द नाइफ उसको भी हटा दो, देन व्हाट रिमेन्स इज वेयर द नाइफ इज, द नाइफ इज बिहाइंड द शिव मंदिर एक्सेट्रा, दैट पार्ट ऑफ सेंटेंस विल बी एडमिसिबल। अब रिमेनिंग पूरा सेंटेंस कन्फेशनल है उसको हटा दीजिए, दैट विल नॉट बी अलाउड either of them। अब ये जो डिस्टिंक्टली वाला पॉइंट है, दिस वाज क्लियरली एक्सप्लेन्ड इन अ केस दैट इज अग्नू नगेशिया वर्सेस स्टेट ऑफ बिहार 1965 सुप्रीम कोर्ट। तो इस केस में डिस्टिंक्टली वाला पार्ट वाज डिस्कस्ड। अब नेक्स्ट पॉइंट यू सी, सिंस द डिस्कवरी वाला स्टेटमेंट इज एडमिसिबल and the point that is relevant is as to how did he has the knowledge। So therefore it is very important that it shall be proved that the object was discovered upon his information only। It is very important that it shall be proved that the object would be discovered upon his information only or his pinpointing only। अब मान लो कोई मर्डर वेपन है और वो खुली जगह पे पड़ा हुआ है। अब पुलिस ने एक्यूज्ड को पकड़ा और उससे पूछा, एक्यूज्ड ने बताया कि मर्डर वेपन तो मैं वहां पर छोड़ कर आया था, खुले में, ओपन में। अब खुले में था तो पुलिस को और भी सोर्सों से इंफॉर्मेशन मिल सकती है। क्या गारंटी है कि एक्यूज्ड नहीं बताया पुलिस को? व्हाट इज द गारंटी दैट ही ओनली टोल्ड टू द पुलिस? हो सकता है पुलिस को किसी और सोर्स से इंफॉर्मेशन मिला और एक्यूज्ड को जबरदस्ती ले गए और उसके सामने डिस्कवर कर लिया। मीन्स एक्यूज्ड को फंसाया भी तो जा सकता है ऐसे। The object is lying in some open place. Police got the information on phone call or something that there is a weapon lying here, and the police knew that accused was there and murder हुआ पिस्टल से, और पुलिस उसको लेके चली गई जबरदस्ती अपने साथ, वहीं पर खड़ा किया और वहीं पर दिखा दिया डिस्कवरी, विटनेस से साइन कराया, डिस्कवरी स्टेटमेंट हो गया, and then they will use that against the accused। So this kind of discovery they will not be allowed। The object which is found, that object should be found from such place which is of the place of hiding, regarding which only the accused may have the knowledge। Then only the knowledge of the accused and the finding of the object can be correlated with each other। If you say that he is the accused and he has the knowledge where the object is, but there are 10 more people who are having the knowledge that where the object is, then obviously in that case the accused knowledge cannot be directly related to the finding of that object. There are chances maybe the police discovered that object on the information of some other person and then implicated and used that as a discovery, and therefore it is essential that the object should have been found, should have been discovered from some place of hiding. It can be any place of hiding, but it must be discovered from some place of hiding. इसको लिख लीजिएगा आप. It is essential that the object should have been discovered from the place of hiding. Only then the knowledge of accused can be directly attributed to the finding of the object. If the object was lying in the open, it could have been known by other people also, and therefore the finding cannot be directly correlated to only the accused. Therefore the finding cannot be directly correlated to only to the accused. तो सारांश क्या है इसका समरी कि ऑब्जेक्ट जहां भी था किसी छुपी हुई जगह पर था. ओपन में अगर है दूसरे लोग उसको देख सकते हैं तो फिर वो डिस्कवरी स्टेटमेंट नहीं माना जाएगा. इट शैल बी फाउंड फ्रॉम सम प्लेस ऑफ हाइडिंग. अब इसके एक दो एग्जाम्पल्स हैं जिसमें कुछ केस लॉज हैं, जैसे मोहम्मद इनायतुल्लाह सिराज अहमद केस इज देयर, इनायतुल्लाह केस इज देयर, सिराज अहमद केस इज देयर. 2-3 केसेस हैं दैट वी हैव टू स्टडी, but that we will continue in the next lecture. Thank you for watching this lecture. That's it for today.